Welcome to the Institute for Strategic Policy Solutions. My name is Kimberly Jackson, and I'm the Executive Director of our think tank located at St. Petersburg College at the Seminole campus. We are honored today to start a three-part series on guardianship, sparked by a prior program we did some time ago and the interest amid COVID on what guardianship means and the appropriate uses of it. So I'm honored to work with colleagues of mine and people who are experts in the industry. Before I introduce them, I'd like to share a little bit about what the Institute for Strategic Policy Solutions is. Briefly, it was created by Congressman Bill Young. It was his idea to think about how we could have nonpartisan conversations on social, political, and economic topics and do it in a way that you understood the scope of government. We're honored and grateful to carry his name and legacy, and we invite you to go to our website where we have a ton of information about our programs, about our history, about our executive directors. We also welcome you to join us on our Facebook page. Now, I'd like to begin by introducing our first speaker, Erica Smith, who is an extraordinary young woman and dedicated to assisting our community. Erica is a St. Petersburg native and a lifelong resident. She is a partner at Fisher & Sauls and the chair of Wills Trust and Estates Department. Fisher & Sauls was founded in 1936 and prides itself on exceptional and personalized legal representation. Ms. Smith practices in the areas of estate planning, probate and trust administration, and guardianships. She received her law degree at Stetson University College of Law. It's also my alma mater. You notice that we have a slight change from what we presented because she's done so much. We felt the need to update her resume at the last minute. Thank you. I'd like to introduce Sancha Brennan. Sancha Brennan is the managing partner of the Brennan Law Firm, a boutique family law firm located in College Park, just north of downtown Orlando, where her practice is concentrated in representing family and professional fiduciaries as they establish, administer, and manage probate, trust, and guardianship estates throughout Central Florida. Sancha is a frequent lecturer and is the annual update author to Florida Guardianship Law and Procedure, a legal practice manual for guardianship law practitioners. She is an active member of the Executive Council for Real Property, Probate, and Trust Law section of the Florida Bar, co-chair of continuing legal education for this section, and co-chair of the Ad Hoc Guardianship Task Force, which has recently completed the arduous task of reviewing and modernizing the entire body of Florida guardianship law proposed Chapter 745. In addition to her work, Sancha is a proud mother of two young and active teenage boys and enjoys volunteering at their schools and meeting and talking with other parents who have children with varying needs. And I appreciate this conversation so much today because as I have always shared, I have a child with exceptional needs. And it's important to me that we broaden the conversation and understanding of the broad scope of what estate planning can do for a family in all levels. So with that, I'd like to turn it over to my colleague, Erica Smith, and thank you in advance for your time. I'm sure we're going to have a lot of questions based on your presentation.
Good morning, Kim. Good morning, everyone. So pleased that you could join us this morning for this discussion on guardianship. As Kim mentioned, this is the first of a three-part series. So some of what we'll be talking about today will actually be taking an even deeper dive in our following two sessions. But I think that today my goal for this is that we all learn the same vocabulary, start with some fundamentals, so that then when we're discussing policy solutions, issues, we at least have a basic understanding of the guardianship process. So this is an introduction to guardianship. As I said, guardianship is currently governed by Florida statutes, Chapter 744. A guardian is a person who has been appointed by the court to act on behalf of a ward's person or property or both. And that's very important. I sometimes get calls from potential clients who begin the conversation, well, I'm my mother's guardian. Have you been appointed by the court? If the answer is no, you're not actually a guardian. You may be acting under a power of attorney, you may simply be helping, but you are not actually a guardian. The guardian, as it says, can act as a guardian of the property as a guardian of the person or as both the person and the property, which is known as a plenary guardianship. The ward is the person for whom the guardian has been appointed. It's important when talking about guardianships that we return to some of the legislative intent that surrounded the formation of the guardianship laws. And I want to touch on just a couple of the points in the first three statements of legislative intent that I think are really important when we talk about guardianships and think about them. The first, adjudicating a person totally incapacitated and in need of a guardian deprives such person of all of his or her civil and legal rights, and that may be unnecessary. Guardianship is typically considered the last means or the last approach. It is a very serious and a very comprehensive matter to strip someone of rights that they would otherwise have. And if we can find a way to help that person to take care of himself or herself and their property without having to do that, that is generally the route that we want to take. That is echoed in number 2, where it talks about being generally desirable to take advantage of the least restrictive form of guardianship, and that there are alternatives to guardianship and less restrictive means. And those can be limited or can include things like guardian advocates, which Sancha is going to discuss a little later in this presentation, and even simply the use of durable powers of attorney or other advanced planning documents. And the third statement, we recognize that every individual is different. We want to use guardianship to promote the public welfare. We want people who are incapacitated and under a guardianship to still be able to participate to the extent that they can as fully as possible in decisions that affect them. We want to help to meet the essential requirements for their physical health and safety. We want to help them manage their financial resources. And if there's a time that guardianship is no longer appropriate, we need to help in order to allow them to regain their abilities to govern themselves and have their rights back. So we are looking for the form of assistance that least interferes with the legal capacity of a person to act on his or her own behalf. And I think that's important. Guardianship is generally not something that we rush into or is necessarily the first line of approach, especially if there are other ways that we can manage without having to use guardianship. So there's 3 types of guardianships that we are going to discuss today. The first is incapacity guardianships. I'll be discussing that. And then Sancha will follow me to discuss minor guardianships and guardian advocacy and less restrictive means of dealing with persons with capacity issues or developmental disabilities. The incapacity guardianship is, I think, what most people think about when they think of a guardianship. Uncle Stan is having some trouble. He has some dementia. He's not able to handle his affairs. We need to figure out a way to help him to get his bills paid on time. He's not taking proper care of himself. He can't bathe and things like that. And we are worried that he needs someone to help him because he can no longer function completely on his own. The incapacity guardianship is unique in that it is the only guardianship in which there is a formal determination of incapacity by the court. That is not the case in a minor guardianship or in a guardian advocacy. So the court in this case is actually making a finding that the person is incapacitated, and then as step 2 is appointing a guardian for that person. So a petition to determine incapacity would be filed by the person seeking the guardianship. Generally, that'll be a family member or a concerned person close to the alleged incapacitated person who believes that they need assistance. And that petition must allege a number of things, but among the most important are facts to support the belief that a person is incapacitated. So what does incapacitated mean in this context? To be incapacitated, a person is either unable to manage their property, And that can mean anything in terms of business dealings, writing checks, keeping their checkbook up to date, using their credit cards effectively, taking care of their house, their real property, or they are unable to meet at least some of their essential health and safety requirements. Essential health and safety requirements refers to things like, are they able to provide for their shelter, their food? Are they able to make sure that they have got groceries for the week? Are they keeping themselves clean? Are they meeting those basic things that keep them comfortable, safe, and healthy? The person alleging that the person is incapacitated must state the rights that the person is incapable of exercising, and they must give the information for the person's treating physician and all of that person's next of kin who need to be notified of this. So these types of guardianships are not supposed to be happening in the dark. They are supposed to be in conjunction with any next of kin that the alleged incapacitated person has. So there are various rights that can be removed from a ward and delegated to a guardian. And those rights are specifically laid out under Florida law, and they include the right to contract, to sue and defend lawsuits, to apply for government benefits, to manage property or to make a gift of someone's property, to determine where the person is going to live, to consent to medical and mental health treatment, and to make decisions about our own social environment or the social aspects of our life. Those, if the court finds that the person is incapacitated, can remove one or more of those rights and essentially give those rights to the guardian to exercise them on behalf of the ward. There's also some rights that can be removed from the ward but cannot be delegated to a guardian. So a court may find that the ward is so incapacitated that they cannot make a knowledgeable decision about whether to marry, to vote, to apply for government benefits. They may not be able to have a driver's license, make decisions about where and when they're going to travel, or seek and retain employment. And the court, in finding so, can remove those rights from that ward, but cannot give those rights to the guardian. Those rights are simply lost. Again, some or all of these rights may be taken away. Not all of them have to be, depending upon the capacity level of the person under the guardianship. In making an incapacity determination, notice must be given by the person seeking the guardianship to the next of kin of the alleged incapacitated person and to the alleged incapacitated person, him or herself. And it must be read to them, to see if they will understand that. We try to keep them as informed as possible that someone is seeking to have them declared incapacitated. At the time that the petition is filed, shortly thereafter, the court will appoint an attorney for that alleged incapacitated person. That attorney is charged with representing the rights of that person in the incapacity hearing. Within 5 days of filing the petition, the court also appoints an examining committee. This examining committee helps the court to determine capacity level by going out, meeting with the alleged incapacitated person, and making some findings about what they are able or not able to do. The examining committee is made up of 3 people. One of those people has to be a psychiatrist or a physician. The other 2 people can be any mix of a number of different professionals, which would include psychologists, gerontologists, licensed social workers, registered nurses, persons with an advanced degree in gerontology, or other persons with specialized knowledge. At least one of the people on the examining committee has to have knowledge about the specific incapacity that is being dealt with in this case. So if we are stating that someone is incapacitated because he or she has Alzheimer's, at least one person on the examining committee must have specific knowledge about Alzheimer's. The examining committee meets with the alleged incapacitated person, performs examinations, which include medical examinations, psychological examinations, and then they each submit a report to the court. And in that court, they detail their findings as to the health of that individual, the capacity level, and what rights they believe that person may still be able to exercise, and what rights should be considered to be granted to the ward or taken away from the alleged incapacitated person. There is an adjudicatory hearing. The alleged incapacitated person, unless they've been specifically excused, must be present at that hearing with their attorney. And the person seeking the incapacity determination must prove that the person is incapacitated by clear and convincing evidence. The court is required to enter an order with its findings, and those findings have to include the nature and the scope of the person's incapacities, as the court finds, the exact areas in which the person lacks capacity to make informed decisions, the specific legal disabilities to which the person is subject, and the specific rights that the person is incapable of exercising. And in doing so, the court will examine any less restrictive alternatives. Again, guardianship is sort of that last resort. So we want to look at whether there are any less restrictive alternatives than having a guardian appointed. The appointment of the guardian is typically going parallel to these incapacity hearings. The person who wishes to be appointed guardian for the alleged incapacitated person has to petition the court to be appointed. And in determining whether that person is an appropriate guardian, the court's going to look at factors that include that person's relation to the incapacitated person, if there are any special reasons why he or she specifically should be appointed guardian in this case, as in, is there something special about their relationship to the person? Is there something special about their skill set or knowledge set that will allow them to best perform these duties? And the court again looks at whether there are less restrictive means. Even if a person is determined incapacitated, they do not necessarily have to have a guardianship if the court determines that there's something less restrictive. And again, Sancha is going to talk about some of those possibilities. Then a hearing on the appointment of the guardian is generally held concurrently with the hearing on the determination of incapacity. So usually all at once, the court will sit down with the alleged incapacitated person, that person's guardian, the person seeking the guardianship with his or her attorney, and then any of the next of kin who wish to be present, and will hear testimony both on the incapacity issue and on the appointment of guardian issue. Guardians have general duties. They are considered a fiduciary, and that means they're held to a higher level of, a higher standard in terms of what they need to do to protect the ward and to act in the ward's best interest. They are allowed only to exercise the rights that have been specifically removed from the ward and delegated to the guardian. If a right has not been removed from the ward and delegated to the guardian does not have the right to take action in that respect. So the guardian acts totally within the scope of authority that's granted within the court. They are to act in good faith. They shall not act in a way that is contrary to the ward's best interest. And in doing that, they need to, hopefully where in most cases the person being appointed as a guardian knows the ward beforehand and knows, how he or she would want to be treated, where they would want to live, that sort of thing, and can act in a manner that, to the extent reasonably practical, meets those goals and desires that the ward would have. And if a guardian has special skills or expertise, or the court has appointed a guardian specifically because the guardian represents that they have special skills or expertise, then they're expected to use those when they're acting for the ward. There are a number of requirements of guardians, continuing requirements, and those are in place because we want to protect the ward. We have all heard horror stories about guardianships gone wrong, and we will be discussing a little bit more of those policy concerns and issues in our second part of this series when we discuss these incapacity guardianships a little more in depth and the legal changes that have been brought about in order to try to meet the need created by some of these bad actors. But as an initial step, the guardians need to take certain actions monitored by the court in an effort to protect the ward. So the guardian needs to file an annual guardianship report with the court. They will file an initial inventory of the ward's property if they are a guardian of the property, and then an initial guardianship report stating where the ward is living, who's taking care of them, what the plan is as far as keeping this person safe and healthy and having social interaction to the extent possible. Then every year after that, they are responsible for filing an updated annual guardianship report, essentially reporting on those same things. How many times has the ward seen the doctor? Are there any new health problems to relate? What is the ward able to do in terms of social interaction? How many times are they getting out and able to see people? That's something that's a possibility. Where are they living? Is that a safe place for them to continue to live? Have there been any new developments of things that maybe they could do before, but now they're not able to, or vice versa? Have they shown the ability to do any of the things that were formerly thought to be beyond their capabilities? In addition to that, the guardian of the property has to file an annual accounting with the court, showing the amount of assets that started in the guardianship account, how those have been spent, and why those have been spent, because they should only be being spent for the needs of the ward, and present that to the court so that the court can review it and just make sure that the guardian is properly utilizing the funds. A guardian can generally not collect any fees for serving as a guardian without petitioning the court and receiving the court's approval. So the court wants to see what the guardian is receiving as remuneration for serving as guardian, and they want to have an opportunity to determine whether this is a reasonable amount. An attorney for the guardian similarly must have his or her attorney fees approved by the court. So each year, when I'm representing a guardian, we will submit a petition to the court that states what our fees were for the year, gives them all of our invoices, allows them to see whether they feel like that is reasonable for the work that we've been doing. And, unless they approve that, we are not able to take those fees. Sometimes that can be done on an annual basis for ratification of fees. Other times, each time that the attorney bills, it needs to go before the court for them to approve that. If the incapacitated person regains some or all of their capacity, the guardianship has to be adjusted or terminated. Guardianships are not necessarily the end of the road for things. There is a constant reevaluation going on in terms of whether the ward remains incapacitated, whether we can give any of those rights back. And that's important because, again, we want to be very careful before removing someone's rights. And certainly if we do so and then they have a change in their situation, we want to be responsive to that and to give those back. Like I said, we're going to take a deeper dive into this topic on March 19th, and I would encourage people who are interested in these incapacity guardianships to tune in. We will be looking at problems within guardianships, how those have been confronted in the law, some changes. These incapacity guardianships are very interesting and they're ever evolving. And I find that the law is created in such a way that if everyone is a good actor, this works beautifully. But unfortunately, we have some bad actors. And when those people find a way to exploit the system, we have to constantly adjust. And I know Sancha can talk some more about that because she's been instrumental in the development and amendment of some of those laws. But I thank you for listening in. I will be back to answer any questions at the end, but I would like to turn it over to Sancha to talk about minor guardianships, guardian advocacies, and other less restrictive means of guardianship.
And before you start, I want to say thank you so much. This information is important. I have new people who are joining in on the call and asking about the presentation. I want to let you all know that we will make everything available afterwards. I would also like to say that if you have any questions, please put them in the chat. We want to make sure that we answer them as many as we can when we get to the moderated portion, but you can put the questions in the chat as of now. And thank you again for your presentation, Erica. Sancha, we look forward to hearing yours.
Thank you. And thank you, Erica. As Erica mentioned and discussed really the incapacity guardianships where you have to go through the incapacity proceeding under 744. So quickly, I wanted to talk about guardianships of children or minors, and then talk about the alternatives to guardianship. So I'm going to try to share my screen, and I'll highlight some things. Let's see. Can y'all see my screen? Should say guardianships of children or minors. That come up? Great. Okay. So in some circumstances, you will have minor children who need to have guardians appointed for them. But for the most part, the natural guardians, which is a term that is defined by statute 744-301, and natural guardians are generally the minor's biological parents or adopted children. If one of the parents passes away, the survivor will be the natural guardian. Otherwise, they have joint ability to make decisions for your children. Then if the marriage is dissolved, if there's a divorce, then the natural guardian will be the parent who is awarded sole parental responsibility. If parental responsibility is shared, then both of the parents will continue as natural guardians. If a child is born out of wedlock, then the mother is going to be the natural guardian and is presumed to have sole custody and control unless there's another court order that changes that for whatever reason. This is also assuming that both of the parents have maintained, have not had their rights removed for some bad act under Chapter 39. Now, there are other times when, like I said, a guardian would need to be appointed by the court instead of just your natural guardian serving. And in those circumstances, a lot of times that will be when there is a financial settlement, whether that is because of an accident or some injury to the child in which they're entitled to receive some remuneration. It could also be if an elderly parent or someone else passes and then they're left a bequest, whether it's an insurance policy or some other financial windfall. And in financial settlements, natural parents are authorized to manage their children's assets so long as that does not exceed $15,000. I think that Britney Spears has been in the news very recently regarding her conservatorship. And conservatorship is very similar to guardianship of the property that we have here in Florida, at least the way that they have set it up. And I think that when you hear conservatorship, that's typically what you're talking about. And a lot of times, at least in Florida, if you've got children who are acting or performing or in other ways have got large sums of money, the idea is to protect that money for the children. So that's why these statutes were created originally. If it is more than $15,000, then the court may appoint a guardian ad guardian ad litem for the minor to help and make sure that there's no conflict of interest and that the minor's interests are being preserved. That could happen there could be an issue there if, for instance, there is an automobile accident. Both the mother or a parent and the child are both injured, both entitled to some kind of a recovery. They could be in a position where the insurance company is going to award one one lump sum and they've got to sort of determine who's entitled to it. And so that kind of puts the parent and the child in a conflict of interest situation. And that's one of the reasons why the court would appoint a guardian ad litem, and they have the ability to do that at the court's discretion at $15,000 or more. If the settlement, however, is more than $50,000, and that is actually $50,000 or more, so $49,999, not necessarily, but if it is $50,000 or more, the court will appoint a guardian ad litem to ensure the interests of the ward are being protected, the minor. In addition, guardians can have the ability to sign waivers and releases. If you are taking your children downhill skiing, snow skiing, they always have you sign away your rights. You have to do that for yourself. They'll have you do that for your minor child too, and you have the ability to do that as well. Plenary guardians of minors, and that is usually, let's see if I can stop sharing for a second. There we go. So other situations when you might have guardians that have nothing to do with settlements could occur if both parents are deceased for whatever reason. We've seen cases where parents are incarcerated, and in those situations, guardians can be appointed. And really, any interested person can file a petition for the appointment of a guardian of a minor. But it's important to keep in mind that custody is different than guardianship. The guardian is the one who's got the authority to make decisions about where that minor is residing. So just because someone is appointed as the guardian of a minor child doesn't necessarily mean they're going to have custody. They may determine the best place for that child to be is living with their aunt for a particular school zone, or there are a lot of reasons why just family dynamic, sometimes that makes more sense. But it is important to remember that there's a difference between custody and guardianship. Let's see. Erica, did you want me to go ahead and move on to alternatives to guardianship at this point? Or do we, I'm not going to bounce back and forth? Okay.
Yeah, I think that would be great, Sandra.
Okay. Happy to do it. All right, I'll share my screen again. So Erica talked about different alternatives to guardianships. And this is very important because guardianships are not proper for everyone. Sometimes it's very difficult to determine when that's the case. But one of the things that we can do, and I encourage clients to do, I think most attorneys do, is to consider these kinds of things before you're in a position where you personally might need to have a guardianship. If you have advanced directives, then that can signify your intention prior to becoming incapacitated and could put you in a position where you can avoid the expense of a guardianship altogether. So advanced directives are documents, and this is set out in Chapter 765 of the Florida statutes. And they're witness documents or oral statements in which instructions are given, expressing the desire of how you as the principal, the person who's executing the document, wish to have your health care managed. And commonly you'll hear designation of healthcare surrogates or living wills considered as advanced directives. There are others. I have clients who confuse sometimes wills and living wills, and really the will is a different kind of an advanced directive, but it's not effective until after someone passes away. So really, what we're going to deal with today are those documents that are helpful to you prior to your demise. Healthcare surrogate designation, which I know I've heard in other states, it's a healthcare proxy. You see them around here sometimes too. Written documents designating a surrogate to make healthcare decisions. And all of these documents have to be signed in a specific way that's laid out in the statute. So it's important to make sure that documents are properly witnessed in order for them to be effective. Healthcare surrogates can make all of the healthcare decisions, and I believe it was 2011 when that statute was, the entire chapter was modified. And there is a statutory form for healthcare surrogate designations that's a number of pages long. Within that document, you can make decisions for this is the term I'm trying to get at, but it's if you want to give your body to science after you pass away, that is something that you can, if you wish, assign to a healthcare surrogate to make those decisions for you if you can't do it for yourself. The standard form right now that's provided in the statutes allows for the document to be effective immediately if the principal wishes for it to be that way, and the primary physician believes that the principal is unable to make healthcare decisions for themselves. There's also a method of authorizing just healthcare information. So if you want your sister or brother to be able to get information about what's happening with you in the hospital, you can choose to do that in the document. The most important thing is that these documents are found. And so documents like healthcare surrogate designations and living wills, they can be, you can execute more than one or have copies delivered. And it is important, I think most attorneys that I've spoken with agree that it's important for you to have these before you're admitted to the hospital. Most of the time, the hospital staff will come around to see if you have a living will or a healthcare surrogate and offer to have you sign them while you're there. But usually when you're in that situation, you are not feeling well. If you are able to express your decision at all about how you want to do that, but there are a lot of ramifications to who you choose as your healthcare surrogate. For instance, it's not always best for a spouse to be a healthcare surrogate. As a principal, you want to know that the person you are appointing to serve as your surrogate is going to make the kinds of healthcare decisions that you would have made. And that can be very difficult on family members to do that. I think a lot of the times we have family members who will get so emotional about the situation and they don't want to let go. And it's very difficult. One of the kindest things that you can do for your healthcare surrogate, the person that is appointed as your healthcare surrogate, is to also execute a living will. And the living will is a written declaration that will direct that healthcare surrogate as to how you would like for your healthcare to be managed when you get to a point where your attending physician and another physician determine that you are either in a terminal condition, end-stage condition, or persistent vegetative state. Essentially, and in the harshest terms, it's pulling the plug. When are we going to remove life-prolonging procedures? And so if you tell those folks exactly what you want, it makes it easier on them to make those hard decisions. Powers of attorney, these are governed under Chapter 709 of the Florida statutes. And this is also a written direction, but the principal's designating an agent, no longer an attorney in fact, which was old law, but the principal appoints an agent to manage their property, their finances, pay their bills, gain access to other financial information, sign contracts. Again, there's a statutory form now, which is multiple pages long for the power of attorney as well. And there are different types. You see specific and limited powers of attorney often in real property transactions. If you want to sell real property, you're going to be out of the country, and you want to assign that to your spouse to be able to sign all of the closing documents to convey real property. You can do that in a specific or a limited power of attorney that is only effective for that particular transaction. Durable powers of attorney are usually what are relied on as an alternative to guardianship, because a durable power of attorney will extend beyond incapacity. So if I have a durable power of attorney that is appointing Erica to serve to manage all of my assets and all of my no assets, it won't be hard, Erica. The durable part of that means that if I'm no longer able to handle that, she can continue to serve unless a petition to determine incapacity has been filed. In that instance, and if she is not a family member, which she is not a family member of mine, the power of attorney will be suspended pending a determination of first least restrictive alternatives to guardianship, and then the guardianship petition. I also mentioned the anatomical gift designation, also in Chapter 765, although I could not come up with the term anatomical gift. This is for organ donors, and there are a number of different ways that you can do that. A lot of people will make that designation on their driver's licenses. You will see that kind of appear in orange typically. But there are also ways to register online or with an organ donor card. You can also direct, funeral arrangements, burial arrangements, and then a pre-need guardian designation. This is prior to your incapacity. You can prepare a document indicating who you would like to be your guardian in the event you are determined to need one. And a pre-need guardian designation will need to be considered by the court at the time a petition to appoint a guardian is considered. Something that I find often is that you have to consider the person that you are appointing to be a pre-need. They may not qualify at the time to be a guardian. They may not qualify to be a guardian at the time you're appointed. So having an alternate is not a bad idea. And some of the ways that could happen is you cannot serve as a guardian if you've had a felony. So, heaven forbid something happens and the person that you've appointed gets into some trouble before you need them, they would no longer be qualified to serve as your guardian. If they are not a family member or related to you by blood and they move out of state, that could also be one of the reasons why someone that you've designated as a pre-need guardian would no longer be qualified to serve as a guardian. So Erica talked to you about a number of different types of guardianships. A pre-need guardian is one that and I usually see this when a guardian is already appointed, but they're concerned whether they are elderly or otherwise, and they would like to make sure that the person that they are caring for and that they have the authority and the responsibility to care for have someone to do that if something should happen to them. So you can do that as a standby guardianship, standby guardian seeking the appointment of a standby guardian who would be available if something should happen to the primary guardian or the initial guardian. Standby guardians, I see this a lot too with parents of adults with disabilities or who have been determined to be incapacitated under 744. They will seek by petition to the court to have another person, whether it's another child, a sibling of the ward, appointed in the event something should happen to them. And again, that person who's designated to be the standby guardian will still need to qualify at the time of appointment, but just and practically the way that works is a guardian, let's say they pass away and a notice will be filed of their passing. The standby guardian has authority to manage the ward and, well, in whatever capacity the initial guardian had. So whether it's guardian of the person, guardian of the property, they can step in for a short period of time, but then will need to file a petition to confirm their appointment as standby guardian. Voluntary guardianships are the most underused part of our statute. You can choose to have someone serve as your guardian, but they will only be able to do that as property, because if you are able to make decisions about your healthcare, your residential and social life, then it's assumed that you ought to be able to do that for your property. So voluntary guardianships you only see with guardianships of the property. I'm going to skip down here to guardian advocates. So guardian advocates are the provision to appoint guardian advocates, Chapter 393. And guardian advocates may be an excellent choice for someone who is able to manage some, but not all of their needs. It originally was designed to assist persons with developmental disabilities. And pardon my scrolling here. There we go. That's a little bit better. And what's important to note here is this is not available to everyone. There is a list of medical diagnoses in which this can be used, and that is an intellectual disability, cerebral palsy, autism, spina bifida, or Prader-Willi syndrome. So if you have a child, for instance, who is becoming an adult and has one of these medical diagnosis prior to their 18th birthday, then a guardian advocacy may be the right choice for you. Now, if they are totally incapacitated and have one of these medical diagnoses, this may not be the best choice. But this really is a way to have a guardian appointed for someone who can manage a good bit of their own life without having an order determining incapacity. This is why this is can often be used as the least restrictive alternative to providing assistance for somebody who needs it without taking away all of their rights. So usually a guardian advocacy proceeding, like I said, it's filed for someone, and I know I have children with special needs and one who is on the spectrum, that's the autism spectrum. And because the spectrum is so wide, there are plenty of young adults who have been diagnosed with autism that may not need a guardianship at all. Some may need a guardian advocacy, and some may really be more appropriate for a 744 guardianship. And we have, I think, scheduled in April, the third of our series in guardianship, where we're going to sort of do more of a deep dive, I think, as Erica said, I like that terminology, into guardian advocacy specifically. Another reason why guardian advocacies can be more appropriate or more desirable for families, let me get here. Got all kinds of great information for you on the third chapter about that. But filing fees. Now, most of the time, and this is under Chapter 744, and I think this is still up to date, but these are costs involved in a Chapter 744 guardianship. And as you can see, you've got two petitions to file. You've got the petition to determine incapacity and the petition for appointment of guardian. A limited guardian, or a petition appointing a guardian of the person only, where there's not a need to manage the property, is almost half of a plenary guardianship petition. Then there's the cost of the court-appointed attorney, unless it is an indigent case. If the ward is determined to be indigent, which can be applied for at the time you file your petition by affidavit, and the clerk will make a determination as to whether they qualify. If that happens, then the state will pick up the costs of the filing fees for the petitions, the examining committee members, their charges, which I have on here, generally range from $150 to $350, although that is that changes by jurisdiction. I've seen $400 recently, so it really kind of depends on where your guardianship is located as to what those charges are and what's acceptable. Let's see, the examining committee, the petition, the filing fees, the attorney who's appointed for the alleged incapacitated person at that point. And then the statutes also provide for certified copies of letters and orders, which a lot of people don't realize. So now in Chapter 393, the guardian advocacy provision, the fees are much less. Again, you can also file these for an indigent person who might have a developmental disability, and the fees are also waived. But in a Chapter 393 guardianship, the guardian advocates are not required to have attorneys represent them. once a guardian advocate is appointed, they are still required to comply with all of the terms of Chapter 744. I see a lot of fellow practitioners who are willing to assist families in having guardian advocates appointed, through the hearing, and then they will withdraw, and the families, once they've taken their guardianship course and they know what their responsibilities and their obligations are with filing their annual reports with the court, they will continue to administer the guardianship without the additional attorney's fees. Now, I can tell you that I have had plenty, and I'm sure Erica has seen this too, but plenty of guardians who come to me because the court is seeking to remove them years later. Recently, very recently, the laws changed with what's required to be included in those guardianship reports for guardian advocates. And if you don't have an attorney and you aren't paying attention to the changes in the law every year, that could affect a guardian advocate if they don't have counsel to rely on. And I would submit to you that guardianship is a very small community of attorneys who practice it regularly. And there are a number of attorneys who think that they understand the intricacies, and they don't. Typically, your criminal attorney isn't going to know that Florida guardianship law is governed by an entirely separate set of rules for the most part. So anyway, Chapter 393 guardianships, that is one of the reasons that the costs involved and the attorney's fees, it's one of the reasons why you see people leaning more toward that. Similar to the incapacity proceeding, guardian advocacies are, the rights are assigned, and the petitioner will include in their petition what rights they wish to have assigned to the guardian advocate. And there is a hearing held similar to the incapacity, or similar to the appointment of guardian, where that will be determined what rights will be assigned. Let's see if I can stop my share there. Okay. So that really covers the alternatives to guardianship for the moment. And if you have any questions, I am happy to address them.
Well, thank you. I have a ton of questions, so you guys can both unmute regularly. I don't even know where to start. I think I'll start with, if you all can just provide context for what do these hearings even look like, whether it's for incapacity or whether it's for minor, or what do they look like? Erica, you mentioned that the judge will go in and have conversations, and I'm trying to bring real life context to what this means to the average family. Because as I was going through this, I was thinking of so many different scenarios of all different families who, because we all have end of life issues, have to go through this. And so you all can bring a lot of context to what that looks like. If you each don't mind sharing your experience about that first. And I'd like to remind everyone that the chat should be enabled now, but please put your questions in the Q&A as the panelists continue. Thank you. Erica, do you want to try and go first?
Sure. In my experience, typically these guardianships are, the hearings are before general magistrates, and they are not as formal as you might think that a court hearing is. The general magistrate is there typically prior to COVID, when everyone could meet together. You would go in around a large table. The alleged incapacitated person and his or her attorney would be there. The guardian and his or her attorney would be there, as well as any interested persons in next of kin. And it is a test, an opportunity to offer evidence. So it is conducted similar to a hearing, but I have found that it is a more user-friendly experience, because in a lot of cases, the alleged incapacitated person is potentially going to have some limitations in what they understand about what's going on, some discomfort in being in a new environment around new people, some hesitation about being in front of a judge. And the the surroundings are meant to try to make that person feel comfortable and try to encourage an atmosphere where the general magistrate can get a feel for the different relationships going on, the alleged incapacitated person's capabilities, which can be hard to determine if they are very anxious or very out of sorts about things. So it is a formal proceeding. I mean, you want to treat it with respect, and there will be evidence taken, but it is not the same as going before a judge in a large courtroom. These are more to put people a little more at ease. Once the general magistrate has made his or her findings, those are submitted to the probate judge for the circuit. And the judge will look at those findings and determine whether they seem adequate for accepting what the general magistrate has suggested. And if they are, then the court officially enters the order ratifying those findings and that decision then. But so hopefully it's not a scary experience for most of the alleged incapacitated people that come. It's not always, a happy experience, but they do try to put them at ease a little bit.
If I may, this is one of the areas that it ranges widely across the state. So Erica, your practice is more in the Tampa Bay, St. Pete area, I believe. I'm Central Florida, Orange, Osceola Lake, Seminole. And here in the courts that I practice in regularly, it's different. So there are some courtrooms where it is the large courtroom with the judge who is sitting above and the bench, and it is that way in Seminole County, for instance, that only has 2 courtrooms where guardianships are held. It is not that way in Orange County. It's typically more in a judge's hearing room, which is 2 long tables, with the judge at one end. It's kind of in a T shape, and that so that appears more informal. And then now with COVID, a lot of these hearings can be held virtually. So I've heard from practitioners in North Florida, for instance, in Union County, they only have probate judges in the circuit up there that are, it's every other week that they're available, and they're covering different jurisdictions. So it really does matter, I think, where you are. But I agree with Eric, and I think that's policy-wise, it should be. If the alleged incapacitated person is going to be appearing at the hearing, then the intention should not be to make them uncomfortable, particularly if they have, a level of diminished incapacity, for sure. But most of the hearings that I have been a part of in the last 20 years, the attorney for the alleged incapacitated person will waive their appearance, so they're not there.
Thank you for sharing that, because it piqued my mind. Even though the fees don't seem exorbitant, they still are fees nonetheless, that I can name a host of people who would not be able to afford those fees, particularly mid-COVID. And then the felony aspect of family members who might be ripe with issues are not necessarily hard criminal issues, but they're felons nonetheless, but they might be in the position to best take care of the family. Is that for all situations? Are there any exceptions to that rule at all?
About the felony?
About the felony and the fees. Are fees waived in any circumstance? And are there any circumstances where the court would provide an exception for a felony?
Do you want to start, Erica?
In my experience, the felonies, no, I have never seen that waived. That's for the protection of the ward, as far as making sure that people who have potentially committed fraud or other issues that might be against the ward's best interest aren't put in charge of the ward's property in person. In terms of the fees, there are certain procedures where you can claim indigency, at least in Pinellas County, and at least some of those fees can be waived. There are also a public guardian will be provided if someone does not have a family member who qualifies or someone that they trust to do it. Then a public guardian will be given, There are attorneys who do certain guardianship work pro bono. I know I have handled some guardianship cases pro bono, representing the proposed guardian. So, and similar, there are attorneys who will work pro bono to represent the alleged incapacitated person. And the court usually knows who those are and will reach out to those attorneys when they get a case in where there is an indigent status. So there are some ways to work with the fees, and there are some allowances for those, if you make that situation known to the court.
So I can just reiterate exactly what Erica just said. The statewide we represent the Osceola County Statewide Public Guardianship Office, and usually if they get, I think it depends on the size of their the area in which they cover and the counties they cover, but I know they have funding for up to 40 wards, so they are constantly carrying a wait list to be able to help alleged incapacitated persons who may not have anybody qualified to help them or family members around at all, and are also indigent or low income. I know that our firm and other firms, guardianship is not the kind of business you get into to make $1 million, or it's not supposed to be. It's not designed that way. So, with the right oversight, and really that comes from the court, I think that's where it should come from. You don't have that problem, but right, the indigency filing, that's a way to deal with some of the initial fees, and then the fees for the attorney's fees for the alleged incapacitated person in the ward. The civil and regional counsel get appointed in cases in Central Florida where the alleged incapacitated persons are indigent, and they've got 1 million cases. They're very busy, but the civil regional counsel attorneys here in Central Florida are fantastic.
I have one more question before I start asking some of our questions from the audience, because I want to make sure for those who may not be able to stay for the extended time get their questions answered. But both of you all mentioned that they can be these certain rights, like to marry, to vote, to apply for benefits, driver's license, for example, travel employment, that they can be removed but not delegated. Are they ever returned? And is there a time period where you reassess someone's capabilities under that scenario? Because I feel like that's a lot of pressure for our guardian to try to determine, right? Especially as myself, I always think about, we all, of course, not with every issue, but, for example, my mother-in-law has Alzheimer's. There have been time periods where I'm thought, you're more lucid than I think you are right now. And there are these periods. So just, food for thought to ask about that.
Well, I could start on that. It can be very difficult. And especially when you have a guardian who is serving, who is a family member, but not necessarily skilled in gerontology or, psychiatry, something like that. There is a requirement when you submit your annual plan every year. There is the position that the incapacitated person sees has to submit a report every year. And they have the opportunity and are required to say which rights, if any, they feel should be restored based on their medical examination of the person. That at least brings in some medical component to it. The other times that I have seen that work is, you're not going to see it as much, I don't think, with, for example, a person with advanced stage Alzheimer's. It's pretty likely that they're going to get a right restored. Where I have seen that in my own cases are cases in which someone is a ward who has some intellectual disabilities, but is still fairly well functioning, and but a situation changes. So, for example, in one of my guardianships, originally the right to marry had been taken away. And this gentleman is pretty high functioning and still social, and did meet a potential mate who he wanted to marry. And the guardian, together with the court, determined that at this point he had significant functionality, that he should be able to make that decision. and that right was restored to him so that he could enter into that marriage. So, sometimes it comes about not so much because the guardian sees something and automatically knows, but because the ward makes a request, and then the guardian and the treating physician and the team involved in the guardianship assesses that anew to decide whether that's appropriate at the time. But it can be very difficult to know when that is appropriate, and sometimes rights are restored and then taken back away later when it's determined, whoops, that was too soon, and that did not work out well. So it can be a series of adjustments to get it right. And the main important factor in all of it is that everyone should always be working towards whatever the incapacitated person's best interest is and trying to get that right. And I think that as long as everyone has the right intentions, it'll usually sort of work itself out. But it is a tricky line to walk.
Yes, the overriding policy for guardianships, as we said before, was to use the least restrictive means available. And the guardian really has an obligation, a responsibility to file a suggestion of capacity, which is the mechanically how that happens is they would file a suggestion of capacity with the court, whether they agree with it or not. If the in my opinion, anyway, my legal opinion, that would be how that is. If the ward expresses an interest in it, and I've had professional guardians that have done that, the ward has expressed an interest, and I want to have the right to make my own social decisions because I want to date this lady who lives across the hall from me. And so, a suggestion of capacity, which is a very short, it's a one-page document, but that's filed with the court. The court will then appoint an examining committee, one. So it is harder to have your rights taken away or removed because that's a panel of 3 physicians or 3 examining members, committee members, who are doing the evaluations to come to that decision. But to have your rights restored, it just takes one examiner who will file the report with the court to have rights restored in that instance. And this can be a problem, just like Erica said, particularly when you have mental health cases. If somebody is diagnosed with a mental health condition, schizophrenia, while they're fine when they're taking their medication, they're fine. But the problem is inherent in their diagnosis that they forget to do it, or they think that they're fine, so they stop doing it. So in those instances, it can be very difficult to kind of manage a guardianship where you've got someone who's able to manage their affairs a portion of the time. And really, I think those are the hardest guardianship cases that we have, because you want to give them, that their rights, they should have their rights if they're able to do it safely and take care of themselves. And I think everybody wants that for them, but sometimes that can be a very difficult decision for the court and for the members of the family and the guardians appointed to help those folks. Also, I wanted to say the felony issue that you had asked before, I forgot to address that. I have not seen any cases where guardians have been appointed if they have felonies, and usually when they file their applications with the court and the petition, the courts are going to do background checks and credit checks to make sure that those guardians are qualified to serve and don't fall under those issues. And those things do come up at hearings. We do have court staff who will bring to the judge's attention if something shows up on that investigation.
Thank you. I think about some programs I did in the past with elderly grandparents who had challenges and not a lot of options for taking care of their grandchildren, and the fear of having to work with another person that may not have known the family very well was the impetus of that question. So thank you for asking it. I want to get to one of the panelist questions who presented 2 actually. And basically it says, how quickly do guardians react to situations that may arise? Because she heard courts who are involved, there are delays in responding to issues. She's a senior with no family in need of representation. One person that she interviewed told her she required total control of investments, and the participant became concerned about that. The other is, can a guardian or guardian advocate act as a power attorney if no family or friend will be appropriate?
Okay, 2 totally very, very different questions. So how quickly do guardians react to situations? Every guardian is different, and I wish I could give you a flat answer to that. They are required. Is it possible to put that back up on the screen just so I can make sure I'm addressing the question? Sorry, that came off, but guardians all react differently. Oftentimes, if I've got family members who really need to have a professional guardian appointed, we'll give them a number of names and have them do interviews. And it sounds like you're doing the right thing in inquiring in that way. You know, a voluntary guardianship might be something that you might consider and talk to your attorney about. You know, appointing, you could have a friend who serves too. And I can carry that over into the question about the power of attorney. You know, if you've got a power of attorney, you may not need a guardian, the appointment of a guardian at all. If there is no family or friend who's appropriate, there are professionals who will serve in those roles for you, professional fiduciaries who do that. And there is a professional fiduciaries council that has a list. It's kind of a new organization that's growing, and there are requirements that they've got to comply with in order to be part of that council. But you know, if you are appointed as a power of attorney and a petition is filed for the appointment of a guardian, usually at the hearing, the court will determine whether or not that power of attorney is sufficient to address your needs, or if the power of attorney will be set aside and the guardian will take control or is assigned the rights to manage your assets for you instead of the power of attorney or the agent under the power of attorney.
I agree with what Sandra was saying, and I sort of echo her response that unless you feel like for some reason you are in specific need of a guardianship, generally at this point, doing some advanced planning with an estate planning attorney in the form of a power of attorney, healthcare directives, potentially a designation of preemie guardian if something should come up where you need someone, is probably sufficient at this point. As far as how nimble a guardianship can be, I have found them, you know, honestly not as nimble as if you just have someone working under a power of attorney, for example, because that person will be able to see the need and respond. Guardians will oftentimes need to, once they've seen the need, go to court and have court approve whatever their proposed action to deal with it is, depending on the situation. And that can cause there to be some time in between. Now, there are some ways to do that through emergency petitions and things like that, but there is some time. The trade-off on that is that the person acting under the power of attorney, although they are a fiduciary and they have duties that they are supposed to be showing you as the principal, is not being at that point monitored by the court. So, you know, they can act quickly, but they're not acting with anyone's oversight. And so that's sort of the trade-off, which is you can get quicker action, but who's watching that? And the guardianship, you know, the action might be a little bit delayed, but you are assured that you know, in many cases, if the guardian goes to the court to get approval, which oftentimes is required before they take certain actions, that, you know, a judge has considered what they want to do and how they want to do it and has found that to be appropriate. So yes, they're a little slower, but they do have that oversight component. But unless there's some reason you feel that you are a candidate who needs a guardianship right now, you know, if you're watching this program and asking these questions, I tend to think that probably, you know, doing some estate planning at this point is better for you than, you know, taking the larger step into a guardianship.
I think too that there are a number of things. I'm sorry, Erica mentioned a lot of the guardians will need to get court authority, and the statutes provide the situations, the rights that guardians have under 744-444 to act without court authority, and what they can do or what they're required to have prior court authority for, and entering into contracts and that sort of thing. But paying your bills, you know, paying, you know, the assisted living facility or your rent or your mortgage and your light bill, those kinds of things are standard, and they wouldn't need to seek court authority to do regular life management type, making those kinds of decisions. But if it is, serious medical decisions, that's different. And I do agree with Erica. I think that it sounds like if you are attending this program, that you're less likely in need of a guardian at this point, and you're asking coherent questions, although I'm not a medical doctor or examiner, you're probably better off contacting your estate planning attorney.
So we have another question, and this is regarding a couple in a divorce situation. If a couple are guardians and subsequently divorce, would the appointment of sole guardian be in the divorce action or back in probate guardian case?
I guess I'll start. If you have co-guardians appointed and they happen to be married, you can have co-guardians that have no relationship to each other at all. You can also have one who's guardian of the person and one who's guardian of the property. So simply a divorce action would not change if the guardianship is already established. So let's say you've already, you're appointed as co-guardians, the guardianship exists, and then the dissolution action is filed. The management of the guardianship and who's appointed in the guardianship would not happen in divorce court. It happens in the guardianship court.
Yeah, just to echo what Sandra's saying, for example, I have a minor guardianship where the child was injured in a school bus accident and got a settlement for that. And the child's parents are divorced, but each of them wanted to be able to protect these funds for the child and to know what was happening with them. So they're actually appointed as co-guardians, even though they're divorced, and that has worked fine for the duration. We're getting ready to end that guardianship because our ward is aging out, but that has worked out fine. So just because there is a divorce does not necessarily mean that you cannot serve as co-guardians. And like Sandra's saying, if the guardianship was already in place, the later divorce will likely have no impact at all on that.
Okay, another question, which I find really interesting and agree with. Should people be concerned with accepting a guardianship? Perhaps they are concerned with level of knowledge, responsibility, legality, etc. I know, Erica, you and I talked about that it is really, as you all said, it's a fiduciary, it's a high responsibility to take on these issues. What is either of your all's experience in people accepting and understanding the level of knowledge that's required to get through these sometimes lifetime requirements and commitments?
That's a great question.
That's a really good question.
Yeah. My partner has a catchphrase that he says to all of our professional guardians, and it's, there is no Martyrs Hall of Fame. There's no Guardianship Martyrs Hall of Fame. I have some professional guardian clients who I would love to have appointed for me when I need one before any family member, because they are so selfless and they're perfectly happy. For instance, you've got a number of incapacitated folks who may have guardianships and they're in assisted living facilities. Their entire days are going from one nursing home to another, to another, to another. You really have to love people to do that job as guardian of the person. You really do. And a guardian, someone who is fantastic at being a guardian of a person and who might have maybe a medical background or some other knowledge base where they come from, may not be the right person to be the guardian of the property. In fact, I find a lot of times that people who are serving as guardian of the property may just not naturally have the best bedside manner. They may have sold thousands of homes and can talk with the financial advisors and really understand how to best manage your funds. But they may not be able to help make decisions or work with your family on determining where the best place is for you to live. So, I think people who are not professional guardians already definitely need to consider it very carefully. Now, there are guardianship education requirements for family guardians and for professional guardians. So when you are appointed, right now under the law, you've got 4 months from the time you're appointed to take a guardianship course. And that depends on if you're a family guardian, there's a 4-hour course, or there's an 8-hour course. So you do get some information. And I know those courses are in the process of being revamped by the Office of Public and Professional Guardians. So it is definitely something to consider. There aren't enough great guardians out there. There aren't. That's one of the reasons why it's such a small community. But if you see what's been happening in the media, they're attacked, and we hear all about the horror stories, but none of the wonderful stories, like my professional guardian who brings all of her wards against attorney advice home at Christmas time. Like, you know, there are just some wonderful, wonderful giving people who don't get enough appreciation.
I would say, you know, in asking who should do this, and in my experience, not always is a family member going to want to do it, or to be able to do it, and there's not any shame in that. I've had a mother tell me with her adult daughter, I just can't be her guardian because of the person, because I can't be with her all the time and do this and worry constantly. You know, she's an adult and I can't control her. And this is just, it's too anxiety producing. And there's not any shame in saying this is not right for me. I've had a brother of a ward who said, I'll be the guardian of the property, but I don't want to be the guardian of the person, because I don't want to have to tell him, no, you can't hang out with this person. You've got to live here. You know, he wanted to make sure that their relationship didn't suffer. And so some of those hard decisions that his brother might not want to hear, he opted to have a professional guardian serve as guardian of the person, and then he served as guardian of the property. And there's nothing wrong with that. I think that if you do take on the responsibility of serving as guardian, it is a high standard. I think that you need to find an attorney who knows guardianship law and communicate with them. The best thing is, prior to taking an action that you're not sure about, talk to the attorney, because the attorney is going to be your resource in terms of guiding you so that you don't accidentally make a wrong decision or a wrong move. So, definitely be represented by someone you trust. And like Sanchez said earlier, not everyone does enough guardianship to do this skillfully for you. So you want to exercise some discretion in who you select to do this. But with their guidance and your good intent, I'm not as concerned about people who are well-intentioned doing something horribly wrong, but more on the toll that it can sometimes take on a person, and is that right for you, and is that right for your relationship with the person? And that's a very fair question to ask, and something that needs to be considered.
Are there any judicial circuit barriers if the incapacitated or disabled person are they're in different counties? Any challenges with that? That was one of the questions.
With a 744, I guess it kind of depends on what type of guardian you are. Guardian of the property, I could be the guardian of the property of someone who lives in Miami, or, because I can do that from here. Guardian, if you're serving as guardian of the person, you've got to be able to, there are requirements to visit with them. I think it's like once every 4 months or something, but you really ought to be, if you're really doing a good job, I think you ought to be laying eyes on, whether it's by video or other, preferably in person. But if you're the guardian of someone's person, you need to be involved and you need to be able to get there. But that doesn't mean you can't live one county over. There are requirements about moving guardianships. If a guardianship is established in Osceola County and the ward is moved to an adjacent county, you don't have to move the jurisdiction. But if it's 2 over, then you do. So from Osceola to Seminole or Volusia County, you'd have to change the jurisdiction of the court proceeding in that instance. But as far as just managing a guardian or managing a ward, if you're a guardian living in another area of the state, it really just depends on what kind and where you are.
I certainly agree. It can be done. I think one thing to remember is that the venue for these guardianships is generally going to be where the ward is located. So if you live in Miami and your ward is in Tallahassee, just be, aware that typically then the guardianship is going to be in Tallahassee and you're going to be dealing with a Leon County court. You're not going to be dealing with your home court. Does that really matter in this day of e-filing and email and that sort of thing? Not necessarily. As long as, like Sanchez said, you can still feel that you can perform all of your duties and not suffer any from not being in close proximity to that person. And as long as you have found a way that works for you to do that, there's not necessarily a restriction on your being able to do that.
So we don't have any additional questions at this time. And so, Sasha, you mentioned we talked about a link earlier that you sent me. Can you explain a little bit about that?
Yes, I just got it recently. So there is a statewide organization, the Florida State Guardianship Association, and kind of in response to and I cannot remember the name of the movie now, but today I think there is a movie that is opening, and it has to do with guardianships. And I think probably it is a likely result of all of the attention that some of the very few bad actors in guardianship, but they're getting a whole lot of attention. And so a movie with some very famous actors is coming out today, and it's got to do with guardianship. And so FSGA is they've previewed it and responded to it. And there's a link with a video about the response, and it's just really explaining, here's what they're saying, but here's really how it happens. Just like in all of these TV drama shows and the court shows, the way that attorneys will argue on TV is not something that would ever be allowed in the courtroom. They'd all be held in contempt of court, and the hearing would never proceed the way it is. So it really is more of a, you've got the dramatization of what this guardianship is, and it wouldn't be a great movie if it wasn't, filled with the drama, right? So that's what this movie is that's coming out, and I'm going to circulate. I hope Kim, you'll be able to circulate or forward that link out to give sort of real life view at how guardianships are and what happens in a guardianship and where that movie may be leading you astray.
One of our participants just said, "Fear the Rain." So I don't know if that's familiar.
I believe the movie that Sanchez is talking about is called I Care a Lot. I think
it's a different one, actually.
Oh, it's a different one? Oh, yes. And there's another one coming
brand new. Yeah, I Care a Lot I think is out already.
Okay.
So you can see this is a really popular topic. I would like to ask from a real world perspective, I brought that up to say, in your personal experiences, if you could give, examples, real case examples of what has been a challenging case and what has been a really productive, successful case. Erica, you just presented one, but at least I do think that anytime a divorced couple can agree to continue on in an appropriate manner in the best interest of their child is always a win. But if you can just give some context to what this looks like from a challenge perspective, regardless if it's a minor or an adult, et cetera. I have, and when I first was approached with this topic, I said, are we really talking about this? But it was as COVID was growing and there were more concerns about how do we handle situations, and not necessarily because of significant issues like Alzheimer's or minor issues. It was more of incapacity issues related to mental health breaks, and working with agencies in the county that said we are overwhelmed with, I think, as you said, Sancha, people were on their meds and decided to get off, or people who are sort of in and out of this flux of the system and have some capability of taking care of themselves, or people who were vulnerable, but people didn't know about it and had a mental break. And now there's more stress on the family because of the additional stresses. So I just wondered if you both could share, as we wrap up with more questions, what is a good win and what's a challenging one?
Well, I can start. I generally find that with my guardianships, my minor guardianships, my guardian advocacies, and my incapacity guardianships where the person is very much incapacitated are generally fairly smooth. the issue, and you just alluded to it, Kim, but the issue is when someone has enough functionality that they can get themselves into situations that are sometimes difficult to reverse. And that's what the guardian is there for, but the guardian is not with them 24/7 generally. So if you have someone who is able to drive, able to go out in public, to make friends, to make bad choices the same way that someone with full capacity can make bad choices, and then sort of cleaning up some of that. So that has been probably the most challenging to me. I have a case with a gentleman who, again, this gentleman is pretty high functionality, but does have some definite limitations in terms of understanding and being able to tell other people's motives and motivations, and making some bad choices in who he associates with, and allowing those people to get him into some scrapes, and trying to go behind him and clean that up. And so most recently he had some friends who talked him into selling his paid off vehicle for a more expensive vehicle that now he has a big loan, and he's not allowed, under the court order, to contract, and he can't enter into financing agreements on his own. And the problem was, by the time that the ward realized what had been done, and we sort of came behind, the dealership wouldn't work with us in terms of reversing that transaction. So we are still in the process of working with the court to try to get some resolution there, to try to make him whole again in terms of having a car that's paid off and not a car that is heavily indebted. But it's those types of things where people can have enough capacity to present as fairly normal functioning and neurotypical individuals, and so they can sort of then make choices, not thinking they're doing anything wrong, and not necessarily doing anything wrong, but choices that they no longer have the capacity to make, and so and probably could or should have been made a little bit differently. So just sort of cleaning those up, I think, is the most challenging situation.
So best case scenarios, a perfect example is I have a client who was appointed, she's a professional guardian, and was appointed for a woman who was elderly, but had been absolutely abandoned by her two children. She was found by the Department of Children and Families, locked basically in her home with rats infestation. She wasn't eating. She was in very, very poor condition. And my client was appointed, and medical condition doesn't necessarily mean you're going to have a guardianship appointed for you, but her medical condition had affected her mental status to such a point that she wasn't able to really communicate very well. So my client was appointed. We were able to get her the appropriate medical care that she needed. Institute actions against her children who had stolen money from her, in addition to other things, just treated her so badly. And ultimately, she was able to be returned to her home with care, caregivers coming periodically, but we were able to, my client was able to restore some of her rights. So, to be able to come in and help somebody who's just been abused and taken advantage of, and really, I think it was an old power of attorney that was how her funds were being stolen. I think that one of her children was actually taking her Social Security checks out, having her sign it, and then getting them cashed, and then she's left with nothing. I mean, she had no food at some point. So those are the feel-good stories. She guardianship was established. She was brought to better health. Because of that, her mental status improved, and some rights were able to be restored to her. And that's a great story. A terrible story that turned great, I guess. But the worst cases for me are the ones where the family members are fighting, and it's usually children who don't agree, and someone was appointed as a power of attorney, and someone else with a healthcare surrogate, and there's distrust in the family. and the fighting and the litigation of that back and forth. And usually, the parent may have some, maybe in need of a limited guardianship, for instance, but they have the burden of their children fighting, and no parent ever wants to have that, but they're living through that. And so that's the worst, because I've seen wards decline because of their children. And I feel grateful when the judge will see that and decide, I don't know who to trust, we're going to appoint a professional. And that is most of the time professionals are appointed. That's why. It's because you've got family members that'll fight, and they will eat up a ward's, entire, eat up their income, eat up their assets, fighting back and forth. And that's not what guardianships are for. So those are the sad ones. Again, with the mental health cases, those are very difficult just on management and walking the fine line of trying to be able to provide the assistance that people need without taking away, without having rights removed. Those are the difficult cases, I think.
Kim, could I just address real fast? There was a late added question to the chat that discussed whether the level of difficulty in moving a ward's residents.
Absolutely.
And,
that would be wonderful. Thank you.
Sure. Generally, in those cases, if you're moving them, like Sanchez said, to a county that's not adjacent to your county, the guardian needs pre-court approval before the move takes place. So you would need to petition the court as guardian and let them know, I'm planning to move the ward's residents. This is why. These are the compelling reasons that I think that this move is in this person's best interest. And if you are able to show that you do have compelling reasons and that the ward will not be adversely affected by this move, or if they will, that at least the benefits to them outweigh any adverse effects, then typically the court will allow you to make that move. But the important thing is that petition needs to be done prior to the move, not after.
I would like to add that if I see this as confusion sometimes with a ward who is moved for, let's say they were in the hospital and released and they're going to be staying in a rehab facility and it's an extended period of time, that is not a reason to change the guardianship, the location and the venue of the guardianship. That is for medical reasons. And there also may be very good reasons why, let's say the ward had a homestead real property, and although they're not living in the homestead, you do not want to do anything that's going to jeopardize that property qualifying as homestead for them. And again, if they're just somewhere, even if it's for an extended period of time for medical reasons, if the intention is for them to come home, and most people want to come home, there are reasons why you want to be careful about doing that.
Absolutely. You always want to look at that intent to remain. Do they have the intent to permanently remain in the new location, or will they be coming back to the location where the guardianship already exists? And if so, then not necessary to change. If they are permanently moving to another county with no intent to return to this one, then that's when you need to petition for that court approval.
I think there is one more question about how long do most actions take normally pre-COVID?
I think that probably depends on where you are in the state, first of all, which judge is assigned, because they all handle things differently. There are requirements. The Florida law provides how long examiners have to, if we're talking about an incapacity, a guardianship that's going to be a determination of incapacity and appointment of guardian. In Central Florida, those two hearings are usually held at the same time, kind of back to back, because if rights are removed, then somebody needs to be appointed to protect the ward. I would say right now in Orange County, and I'm afraid to put a number on it because somebody's going to hold me to it, but I think if we file a petition right now, and keeping in mind that in a lot of circuits, you've got new judges who are just on the bench as of January 1st and still sort of getting their the administration of their courtroom kind of set out, we can get hearings for incapacities within a couple of weeks. but you still have to have the time built in for the examiners to go out and visit with the ward and file their reports. And they've got 50, it's supposed to be done unless it's waived 15 days before the hearing. So there are a lot of timelines built into the existing statute to kind of let that happen. It really shouldn't be no more than like, I don't know, we usually say like 2 months, 2-3 months, but in some areas it can happen sooner because of COVID and the move to online hearings. I think, there are still emergency temporary guardianships, and those can happen and are designed to happen much more quickly. And that is only if the alleged incapacitated person is in danger of harming themselves or having their assets or their person danger. I'm not using the right words today, but I know Erica's going to fix that for me.
I think that's pretty close to Pinellas. I was going to guesstimate usually around 2 to 3 months. I really haven't seen, at least in our jurisdiction, a change in whether the courts are more available for hearings based on COVID. It seems to be taking about the same amount of time. So setting hearings are being set out about the same amount of time as they would be. We haven't seen much improvement in being able to get things heard sooner, but there is that period of time where the examining committee needs to be, assigned, have a chance to see the ward, the court needs to be able to see their report. But like Sanchez said, there are guidelines in the statutes too that monitor, within X number of days, this needs to happen. So you generally don't have a guardianship that's just hanging out there unattended because they do need to meet those statutes, but it can take 2 to 3 months to wrap up, especially depending on how quickly you can get a hearing date.
Well, ladies, I can't thank you enough for your time and for doing this I think this is a wonderful introductory that we hope to share broadly. And I think it is a teaching moment for many people where they can hear it in plain language and really absorb it before making decisions. As you just share your final thoughts before we wrap up, there is one more question that I would like you to contemplate, and the variance in state guardianships, if you want to speak to that, if you'll give your final thoughts. And I want to also tell the participants, thank you for your time. This has been recorded. We will share it, and we will share it on our website. We will let you know when we've been approved for CLE credit or continuing credit in general, and we will make sure that this is broadly supported among many organizations where we think this is really key information. So with that, Erica, then Sancha, and then I'll do our wrap up.
I'd just like to say again, Kim and ISPS, thank you so much for having me. I'm excited to have an opportunity to talk about the topic of guardianships. And, I'm so glad there's public interest in learning more about this. I highly recommend that anyone who is interested in these topics join us for our next 2 parts of the series. And we'll be exploring them a little more in depth and, talking about some of the issues alluded to today with the public interest in some of the more scandalous stories that have happened with guardianships, how laws are, are constantly changed to try to respond to bad actors. Generally, it is not that it is a bad law, it is that it is a bad actor. And we just continue to improve the law to try to deal with those people. So look forward to exploring those topics in March and April. And I look forward to seeing people and having an opportunity to discuss guardianships again. Thank you so much.
So to address well, let me say this first. I stand corrected. Erica was right. The movie is I Care a Lot. So I apologize. I don't know what I thought it was, but that is the movie that's coming out today that the FSGA has submitted a response to. And for the question that came up, is there wide variance state to state in guardianship? Absolutely. There is a uniform guardianship code that's been adopted by a number of states, and it is an issue of great discussion among the real property, probate, and trust law section of the Florida Bar and the elder law section of the Florida Bar for various reasons. And in my work on the ad hoc committee that it's been an 8-year project to develop an entire new body of guardianship law, the Guardianship Code, which is proposed as 745. We had a survey done of guardianship laws throughout the nation. And one of the things that we determined is that the establishment of guardianships from state to state is just vastly different. You have some states that don't have an examining committee. You have some states where you can just make a suggestion. There's no doctor's examination at all, and guardianships can be established. And to have, it really is a matter of due process. And in Florida, the guardianship laws have constantly, but they were codified in the early 90s here in Florida. And because of our extremely large elder population, I think that we focus more on due process here. And Florida guardianship law is by far more protective of our words than in other states. So although we have a uniform guardianship code that's out there that some states have adopted, it doesn't include protections that Florida has, like monitors, they're called guardianship court monitors right now. But so there are a number of protections in Florida that we have that other states don't have. So I'm a huge fan of Florida guardianship law and the work that the attorneys and my colleagues and other stakeholders in the state. I mean, a lot of people who care a lot about our disabled and elder population, and we're trying to do our best to work together to make sure that lasts. And I also want to thank you, Kimberly. Thank you, Erica. Thank you, St. Petersburg College and ISPS for the opportunity to speak today. And I will look forward to doing that again in our next series. Thank you.
Thank you. Thank you. You guys have been incredible. So we're going to wrap up today. And again, thank you for taking the time to stay with us. We have some upcoming events we'd like to share. The first one is next week we have Florida Supreme Court Justice Peggy Quince, the former justice, who at the request of our St. Petersburg College Student Life and Leadership agreed to join and just to talk about what does justice mean. So we hope you'll join us. It's a collaboration with our students and we always enjoy that. The next slide, please. And we have a series on health equity and access with Leadership St. Petersburg Alumni Association. And we wanted to take on COVID. Of course, COVID has been a huge part of all of our lives, whether you've lost someone or you just know someone who's been impacted by it. So we want to just talk about the conversation specific to how it is impacting us here. And in the next series after that, we'll have a statewide lens with Dr. Coey of the Florida Department of Health. And then lastly, we'll have a physician perspective. So that will also be a series. As you heard, we have our next series with guardianship. Part 2, and that's a deeper dive. And we look forward to your questions. We ask you to spread the word. This is an important conversation. Again, it was sparked by just a question and an email that just evolved. And I learned so many people had these specific questions about guardianship. And I thought it's time to educate, which is what we do best at ISPS. And I think we have one final slide. And the last one is we had a cybersecurity breach in Oldsmar. And so we want to learn more about what is hacking, how is it happening to infrastructure, and what can we learn from the Oldsmar case. So we hope you join us for these programs and more. And again, thank you for your time. We wish you well and continue to join us on our website or our Facebook page to learn more about what ISPS does. Have a great one.